Dictation will start in 5 seconds. Start. This court, having heard learned counsel for the parties and having perused the material available on record, is of the considered view that the present petition raises substantial questions of law and requires adjudication on merits. Stop. The petitioner has assailed the impugned order primarily on the ground that the same has been passed in violation of the principles of natural justice and without affording any adequate opportunity of hearing. Stop. It is contended that the authority concerned failed to consider the relevant documents placed on record and proceeded to decide the matter in a mechanical manner, thereby causing serious prejudice to the rights of the petitioner. Stop. On the other hand, learned counsel, appearing on behalf of the respondent, has opposed the petition and submitted that the impugned order has been passed strictly in accordance with law and after due application of mind. Stop. It is further submitted that the petitioner was granted sufficient opportunities to present his case. However, he failed to avail the same and cannot now be permitted to take advantage of his own lapses. Stop. The respondent has also contended that the scope of judicial review in such matters is limited and this court ought not to interfere unless the impugned order is shown to be perverse or arbitrary. Stop. Having considered the rival submissions, this court finds that the record does not reflect proper consideration of the material evidence placed by the petitioner. Stop. The impugned order is conspicuously silent on several crucial aspects which go to the root of the matter. Stop. It is a settled proposition of law that every quasi-judicial authority is required to pass a reasoned and speaking order indicating due application of mind. Stop. Failure to do so renders the order unsustainable in the eyes of law. Stop. Accordingly, the present petition is allowed. Stop. The impugned order is hereby set aside and the matter is remanded back to the competent authority for fresh consideration in accordance with law. Stop. The authority shall pass a reasoned order after affording adequate opportunity of hearing to all concerned parties. Stop. No order as to costs. Stop. The parties are directed to appear before the competent authority within a period of 4 weeks from today. Stop. The authority shall thereafter proceed to decide the matter expeditiously within a further period of 3 months in accordance with law. Stop.